Hi everyone. So in this video, we are going to explain the next set of questions 3B, 3C and 3D in civil paper AP JCJ mains examination. So in this part 4 of the video, we'll be covering 3 questions. So do not miss any of the question, and if you are having any query, make a note and write your answers for your reference. So while moving on to the question 3B, to what extent can a defendant whose defense has been struck off under Order 15A of CPC participate in the trial? So this is the question. So by this you can understand this is regarding Order 15A. So what is Order 15A? This is regarding case management hearing. So under CPC, Order 15A is case management hearing. So when a defendant's defense is struck off under this order, it means that court has taken the severe step. So here what they have mentioned in the question is if the defense of a defendant is struck off by the court. So the defense is struck off by the court. So that means here the court has been taking the severe step of disallowing the defendant to defend his case. So it has been disallowing the defendant from defending his case. So due to the failure to comply with certain court orders, so the defendant has to comply with certain court orders. And the question here is, after even the striking off of the defense, can he still enter into or participate in the trial? Yes, he can still enter and participate into the trial by showing valid or reasonable reasons to the court where the court agrees the reasons to be valid. So generally what happens is when the defense is struck off, it means that the defendant has totally lost their rights, such as to file a written statement or to contest the plaintiff claims, or the defendant may not have the opportunity to cross-examine the plaintiff witness. So there are such situations where if the defense is struck off by the court, the defendant loses all these rights, right? So the defendant can apply to the court to set aside the order striking the defense. So he can ask to set aside the order, or he can urge the court to set aside the order which has been passed by the court that the defense is struck off by showing some valid reasons to the court. But if still the court finds those reasons as invalid, so they are not valid, then the court can issue cost or penalties on the defendant for failure to comply with orders of the court and for not showing valid reasons. So this is the case in the case management hearing 15A, the answer for this question. So going to the next question, can a pendenti light purchaser seek restoration of property under Rule 99 of Order 21 CPC when he has been dispossessed by the decree holder? Explain. So first, to understand this question, we'll be going through Order 21. So Order 21 is regarding execution of decrees and orders, and Rule 99 in Order 21 speaks about dispossession. Dispossession means It's an action of depriving someone's land. Okay. So rule 99 speaks about dispossession by decree holder or purchaser. So by this question, what is the answer? So when he can be dispossessed by the decree holder. So that means can a pendentilite purchaser. So here we learn the terms also. What is a pendentilite purchaser? So here there are generally two terms. One is pendentilite and the other term which you have to know is lis pendens. Generally these two terms are mostly similar, but pendentilite refers to a pending lawsuit. So this refers to a pending lawsuit in the court, whereas lis pendens is also the same, but it is a document filed in particular public records where the real property is located and stating that the pending lawsuit will affect that such property. So this is a document file. Okay, so now the question is, can a pendentilite purchaser? So pendentilite, you already know the meaning, a pending lawsuit in the court. So now who is a pendentilite purchaser? So a pendentilite purchaser is nothing but pendentilite purchaser. So we'll be learning now. So as I said, pendentilite means a pending suit in a court. A pending lawsuit in the court is called as pendentilite. So who is a pendentilite purchaser? So the purchaser who has purchased the land or some set particular property when the case related to this property is still pending in the court. So during the pendency of a suit regarding land or regarding some property, if still the purchaser has bought that land, then the purchaser will be termed as a pendentilite purchaser. So by doing such act, the purchaser will be definitely bound by the result of the litigation. So he has to oblige with the result of this litigation. So where any person, so any person other than the judgment debtor, so the judgment debtor is dispossessed of the immovable property by the decree holder, or where such property has been sold in execution of a decree, then this purchaser will definitely have a right and he can apply to the court stating that for restoration of for restoration of possession. So as he has purchased the land or the property, so as the purchaser has purchased the land or some property while still the suit is pending, and as a result of litigation he have a right to ask for restoration of possession by stating the reason that this entire act has been made wrongfully or illegally. So he has been wrongfully or illegally possessed. So he has been wrongfully or illegally dispossessed. So the pendentilite purchaser need to file an application before the court. So he has to file the application before the court which has passed such decree. And he should also state such circumstances in detail why it is being believed as dispossessed. So he has to state reasons why it is being believed as dispossessed, and always in such scenario the burden of proof lies on the party who is asking for or who is seeking for restoration. That means on the purchaser. So here for this question, the answer is, can a pendentilite purchaser seek restoration of property Yes, he can seek the restoration of property by showing that he has been dispossessed by the decree holder according to Rule 99 of Order 21 of CPC, and he has to prove that he has been dispossessed either wrongfully or illegally by the decree holder. So hope you understood this question, and we'll be next going to the other question. Who is a necessary party and who is a proper party? So this is one of the important questions in CPC. So who is a necessary party and who is a proper party in applications filed to implement them in pending suits? So you have to know the difference between necessary party and the proper party. So firstly, I'll tell you, necessary party is also being called as indispensable party, and a proper party can be also termed as permissible party. So who are these parties exactly? We'll just know in this question. So indispensable party. So a necessary party is one without whom no order can be passed. So no order can be passed or made effectively. So these parties should be present when an order is being made by the court. So that party is called as necessary party. That means it's compulsory for these parties to be present while the court passes the order or makes the order. Then what is a permissible party or proper party? Here, in whose absence an orders or an effective orders can be made. So in whose absence the effective orders can be made, but whose presence is necessary while taking final decision. So here necessary party, it's clear, no order can be made if any of the necessary party is not present. But a proper party means in whose absence the order can be made, but while delivering the final decision they have to be present. So this is the main difference. So the necessary parties can be plaintiff and defendant. Whereas, for example, a proper party can be some parties such as who are having relation with the parties with indirect or having contingent interest related to that suit, or the parties who can be affected by the outcome of decision given by the court, but they do not form center of the main dispute. So they do not form the center of the main dispute. So this is regarding a necessary party and a proper party. So all the sub questions 3A, B, C, D, all the sub questions are for 2.5 marks, and if you can see, you can go through all these questions which have been stated under 3B, C and D. So if you like this video, do not forget to like the video and share the video with all the aspirants who are willing to learn these questions.